or PP. This is the petitioner's motion to terminate a personal protection order. Plaintiff is present in the courtroom. She is in pro se. The defendant is in the courtroom in pro se. Will both parties please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Put your head down. The court, back on January 22nd, 2024, had issued a personal protection order. The petitioner in this case, Ms. Glinkerman, had filed a petition with this court. On that date, the court, based upon the information contained within the file, it stated authorized the petition, and the very first alleged incident that the court relied upon in issuing the personal protection order is as follows. The latest incident started in early to mid-December 2023 with mental and emotional abuse. December 25th was the final incident. Kent Kruger and I started arguing earlier that morning, which resulted in him cutting my arm with a knife, which I received 5 stitches for later in the day. Later in the afternoon / evening of December 25th, while his children were at home, Kent accused me of stealing baseball cards, got angry, hit me in the head with a metal box. Kent's daughter called the police and I was taken to the emergency room where I had been examined and received my stitches. There are other alleged incidents in this matter as well. Since the granting of the personal protection order, the petitioner has filed a motion to terminate the personal protection order, where on March 15, 2024, according to the document filed with the clerk of court, I, Leslie Glinkerman, have good cause to terminate the PPO against Kruger. I lied about the abuse and made up the story of Kent cutting my arm. I did this so I would have a place to stay at the shelter. Ms. Glinkerman, do you have any comment regarding that?
I'm sorry that I lied and caused all this hassle of everything that's going on. It was a big mix-up about Christmas. It was a big mix-up about other stuff. I was mentally ill. He was also mentally ill, and I'm sorry.
Just a moment, Ms. Glinkerman. You had stated, you just stated a moment ago, alleged mental health issues, but you filed this on, the document that you filed with the court was dated January 1, but you filed it on January 16. Correct? According to the file.
January, yes.
Okay.
Because of what I was saying. Yeah.
So this is the problem with matters like this. In general, personal protection orders are extremely serious matters. And you lied to the court. First, I'm going to terminate the personal protection order. That's number one. Number two, I'm holding you in contempt. As a result of that, at this time, I'm not going to make a determination regarding disposition because at this point, I'm going to assign an attorney to represent me. This is frankly criminal contempt. My understanding is, well, as a result of this, right, just a moment, please. You have an attorney representing you in another matter right now?
Yes.
What's that attorney's name?
Lockhart.
Mr. Lockhart? Okay. The court will appoint Andrew Lockhart to represent you. We will set this for a disposition hearing next Friday at 9 a.m.
Next Friday at 9.
Pardon me?
Next Friday at 9.
Next Friday at 9. Don't ever do this again.
Will not happen again.
This is hearing regarding, frankly, a show cause of Mr. Paige. Ms. Oswald is present. She's in pro se. For purposes of the record this morning, the court, through our deputy court administrator, received a telephone call from Mark Stephen, a person identifying himself as Mark Stephen Paige. He had stated that he called this morning essentially asking for an adjournment He also made statements regarding maybe a child just recently being born. It was a very difficult phone call that Ms. McNames had taken because the connection was so bad. I believe he also stated that he was approximately 3 hours away. Zoom information was provided to Mr. Paige. However, based upon his terrible cellular connection, and I'm not blaming him, but his location, the cellular coverage was abysmal. The communication between Ms. McNames and Mr. Paige was difficult because of the connection. And Ms. McNames, is that a fair assessment?
Correct, Judge.
Thank you. Regardless, Mr. Paige calls this morning requesting an adjournment. He advised the Ms. McNames that he has not paid the monetary obligation due of $100 by March 22nd, 2024. And Ms. Schultz, has there been any development on that?
No, Your Honor. We had a hearing on March 1st. The court did find Mr. Paige in contempt for a violation of the communication provisions, and he was assessed a $100 sanction payable by March 22nd. That was not paid timely, so we did notice the hearing for today in an effort to hopefully have them comply with the order. However, there has been no payment received by our office.
Thank you, Schultz. All right. As a result of that, at this time, Mr. Paige has until 12 noon to report to the court to address this matter. If he fails to report at this time, and clearly notice was properly provided because he called this morning advising that he's aware of the proceedings and then requested an adjournment. If he fails to appear by noon today, bench warrant will be issued for his arrest. The amount of bond in this matter will be maybe $200 cash assured. Ms. Schultz, do you have anything further?
No, Your Honor, thank you.
We're all set, Miss. Sorry you had to appear for this.
Oh, like I told her, it's better safe than sorry.
Okay, thank you. All right, we have an individual on our screen. Your name, please.
Mark Paige, can you hear me now?
Oh, Mr. Paige. Okay, Mr. Paige. Let me place you under oath. Would you raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Mr. Paige, you may put your hand down. We just addressed this matter a moment ago because you did call clerk, our deputy court administrator requesting an adjournment in this matter. Have you paid the $100 that was due on March 22nd?
No, sir. I ended up losing my job. I literally just started back into my construction season, and I could have the money for you guys next Friday.
You can have it when?
Next Friday. I just started my construction job back. Like between trying to take care of my son, I just had like I wasn't making much, and my unemployment was only $400 a month because I was steady getting money taken out of it for child support.
Schultz, do you have any comment?
If the court wishes to preserve the issue for 14 days, allow time for the payment if it needs to be renoticed in front of the court.
All right. Thank you, Schultz. Mr. Paige, you can't call the morning of the hearing requesting an adjournment when you've had since March 22nd to address this. The court already ordered that. Just a moment, sir. I'm sorry. The court already addressed the matter and advised that if you didn't show up to the court by noon today to address this matter, then the bench warrant will be issued for your arrest. You're stating that you can have the payment by next Friday?
Yes, sir.
All right. I'm going to reschedule this for next Friday, 9 a.m. If payment is made prior to next Friday, Mr. Paige, you need not appear. If payment is not received to the front of the court by Friday morning at 9 a.m., you need to appear in the courtroom and explain why. And at that time, you could be held in contempt. The court will reverse its decision earlier based upon your appearance this morning. I'll give you grace of 7 days, but you need to have this paid. And if not, you need to be in this courtroom next Friday at 7 a.m. to explain why you did it. 9 a.m. I'm sorry, 7 a.m. My goodness. Do you have any questions, sir?
No, sir. I appreciate the 7-day grace period.
All right. All right. Not 7, 9. I won't even be here at 7, to be honest with you. So we'll see. Hopefully not see you next Friday at 9. Make sure you get that payment to the front of the court and we move forward.
All right, sir.
Thank you.
Thank you.
Yes, this is the plaintiff's motion regarding parenting time and other matters. Ms. Oswald is in the courtroom. The court inquired of Mr. Paige earlier, and he's not checked in. He's also not checked in via Zoom this morning. Matter is scheduled for 9 a.m. Prior to going onto the record, the court inquired of Ms. Oswald whether or not Mr. Paige might be appearing this morning, and Ms. Oswald indicated to the court that she has not heard from him since the first of the month. Is that correct?
Yes, sir.
Is that a correct dissertation of our conversation just a few moments ago?
Yes, sir.
Also part of the conversation was the statement by Ms. Oswald that she is to be at work at 10 a.m. this morning and works in Minden City. And the court was going to wait until 10 o'clock to address the matter. However, it is 9:33 and Mr. Paige has not checked in with the court. So we are going to proceed in the case. What is the issue here regarding parenting time?
We had originally spoken about the summertime situation with him having the little one for 2 weeks and myself a week. I've been dealing with severe PTSD issues due to the circumstances that actually brought us into court. He had her for the entirety of Easter and spring break together, so it was almost a week and a half. And when he refused to let me speak with her, I went through extreme PTSD issues to the point my insomnia kicked in really badly and I did not sleep for 4 days.
Now, he was entitled to the child at that time, correct?
Yes, sir.
Okay.
And I had no problem with him having her. I just wanted to talk with her to be able to, I guess you could say, calm myself. But he was denying any sort of communication between she and I.
How old is the child?
6.
So is there any talk time provisions?
We haven't had any discussed here in court yet.
Okay. Do you have any proposals?
When she's with him for long periods of time, I would at least like to be able to speak with her at least once or twice if she's with him for more than a week. Like, she and I haven't really been apart except for the 10 days that she was gone in the end of September, beginning of October, which brought us here. And then the longest time frame that she's been gone since then was the spring break and Easter break combined.
And the summer parenting time is he would have 2 weeks with the child, you would 1 week.
Yes, sir. I was wondering if there was any way that we could change it week to week, because I have been having extreme issues with getting Mr. Paige to respond as a proper, calm adult on any situation.
Now, I'm requesting, let's assume hypothetically the order continues as it has been. You're not requesting a change, just hypothetically speaking. If he has the child 2 weeks, you have 1 week, how many times per week do you want to be able to have contact with the child?
If he has her 2 weeks, I would very much appreciate if I could talk to her at least twice a week,
Twice a week.
because she and I are all together.
All right, so what days and times would be best for you?
Mondays for sure, and any other day of the week after that.
Okay. Well, since Mr. Paige isn't here, do you know his work? I'm not asking you whether or not you know everything about.
Oh, no, I can tell you his
work.
work style schedule. I'm the one that got him the job, sir.
Okay.
So he does road construction during the spring, summer, and fall. He literally works anywhere from 6 to 7 days a week, generally only completely off if it's raining.
Okay. So Mondays and what other day during the week that would you prefer?
Thursday or Friday would be fabulous if possible.
What time for each contact?
I want to say roughly about 6 p.m. if that would be okay, because it's not too late, so she'd still be up. But at the same time, it's not too early to potentially disrupt his entire schedule. I'm hoping he would be home by that time frame, because he's usually gone from his place of residence by no later than 4:30, 5 o'clock in the morning, and there's no given time on him getting home at night. That was another reason why I was wondering about the change possibility for, instead of 2 weeks with him in a row, if it would be possible for a week, because she's not really going to be seeing him as much as should be, if that makes sense.
No, I understand that. Unfortunately, though, when it comes to a parenting time schedule such as that, if a parent decides he or she doesn't even want to have that time period, which to me is a complete crime in and of itself. If you have time with the child, you should be exercising it. The parent can do whatever they wish with the child. Can leave, unfortunately, at a daycare or with Nana or with another family member. They could do that so long as the child is safe. I know that sounds crude, but that's how this works, unless there's some potential harm that could be exhibited or shown relative to the child. But the communication that you're proposing, do you use FaceTime? Do you use
We use the app.
which one?
Uh,
The app post?
Yeah, that one.
That is a video feature.
Yes, sir.
And is that how you communicate with Mr. Page?
Yes, the only time that we communicate outside of the app is if something emergency wise comes up or like a death in the family or anything of that sort.
Good, okay. What is this regarding Mr. Page's girlfriend?
I have been receiving random numbers texting me, and I have actually been able to figure out that it is his girlfriend that is sending me these harassing text messages. If you'd like to see just the messages off of one phone number, I have them printed off.
Just give me an example of some of the messages you claim is coming from her.
It's verbally not a good thing to speak of.
I see. Do you wish to have this marked as an exhibit?
Yes, please.
We'll mark it as plaintiff's one. Please hand those to court administrator. We'll have them marked momentarily. One.
With all of the pictures, when you get to the very end, that is the reason I was able to figure out who was sending me the text messages. Because at the very end of all of it, there was a picture of a person's Snapchat taken, and it was then the pictures at the bottom of their screenshot that actually showed me who it was. I don't know if they're going to be clear enough on the print offs.
So these depictions here, you can identify that individual?
Yes, sir. Because of the way that she was speaking and the way that she has verbally attacked me on phone calls previously, the style of speaking combined with the pictures at the bottom, I don't know if you recall, but the last time that we were in here for his contempt of court situation, he had mentioned that he had a newborn. And in the pictures that I had blown up, you can clearly see that his other child is being involved in this in a way, because that's how I honestly figured it all out.
The individual that's depicted, not the child, but the individual depicted what appears to be a darker top. Can you identify who that person is?
So with that, the person that is in the pictures all the way to the right-hand side of that would be his new girlfriend. I can't even give you an actual name of her because he seems to think it's perfectly fine to not let me know who's around my child consistently when he knows exactly who has been around my little one on my end.
So, but how do you know this? Have you ever seen his new girlfriend?
Yes, sir.
Okay, is that the same person?
Yes, sir.
Okay, so you are identified.
I just can't give you a name or anything because I do not know.
What about the switch games?
He has yet to return them. She had taken them down, I want to say either towards the end of November, beginning of December, after you guys had stated that whatever she takes down, she brings back home. And he has yet to return them. He's been, and I don't know for sure, but I do believe it's in the paperwork that I had turned into Mitch the last time that I had handed in conversations about there's been multiple times where I've asked him, can you please return this on this date? Can you please return this on this date? And he continuously says, well, now that you get child support, you don't need to have it sent back to you. You can just go buy a new one.
So other than the switch game, and I'm assuming there are components with that.
I thankfully have the switch system. I have the controllers, I have the charger port, I just do not have any of her games.
What else are you requesting to be returned?
As of right now, those are the only things that she and I can find that are missing.
No other clothing that she brought with her that she intended to bring back?
Just gotchis.
Anything from the front of the court that's fine? I believe we also have another hearing scheduled at the end of the month. Or am I thinking of another file?
No, that's
Okay, disregard. I'm incorrect on that. I'll take responsibility. Okay, well, the issue though is you're requesting the parenting time that's originally ordered to be modified, and there has to be proper cause or a change in circumstance. It's probable cause standard, more likely than not. This is what has to be shown. What has been alleged is that since one extended period of time, including the Easter holiday and the spring break portion, the child was with father for longer than a week. Mother complains of having PTSD issues relative to that. Also, she is alleging items that are being sent out are not being returned, including the switch games, and there are allegations regarding the defendant's girlfriend that that she is messaging the plaintiff in this matter. Parties have joint legal custody though, correct?
Right.
Okay. There's an issue regarding the haircut as well. I forgot to mention that.
My daughter had not had a haircut in her entire life. When she went down to her father's over Easter break, when she came back, her braids were significantly shorter. He chose to completely ignore me when I was just trying to find out information. Had he at least let me know something or asked, hey, is it cool if I do this? I would have had no issues. But with the factor being that I literally had to ask his sister, who is the beautician that cut her hair, if it was the situation that had happened, it's frustrating to say the least, because I did not have any plans to have my daughter's haircut in any way, shape, or form until she chose it.
Did you file a complaint with the friend of the court relative to the hair issue?
I don't believe so.
Then I'm assuming then a show cause here.
The friend of the court, where we do have authority to get involved in those types of decisions, we generally will decline to the parties and bring that action to the court.
Okay, fair enough, fair enough. I'm not trying to pass the buck either, but I just want to make sure I have everything correct here. Problem is Mr. Paige is not here. He was properly served in this matter. So you're stating with joint legal custody, you're supposed to communicate with each other relative to this, and he didn't communicate, and you're stating on the record, under oath, that your child's hair was cut without your permission.
Yes, sir.
Okay. Very well. Going to order a fine, Mr. Paige, amount of $100. Violation of court orders relative to joint legal custody. That'll be due and payable by May 31, 2024. Relative to the property that's has allegedly not been returned, the court will order that he is to return the property back, specifically the switch games and any underwear, correct?
Yes, sir.
Of the child that was brought to the parenting time and expected to be returned. That will also need to be done. I'll make it at the same time, May 31st. By 4 p.m. Relative to the parenting time issue in this case, I don't find any proper cause or change in circumstance. However, the court is going to order in this matter that mother is awarded video time or communication with the child during father's parenting time 2 times per week on Mondays at 6 p.m. and Thursdays at 6 p.m. If Thursday doesn't work, then it will be Friday at 6 p.m. By the app close program or app. But changing the summertime parenting time in this matter, again, unfortunately, I don't find a proper cause of change in circumstance.
I understand that. Is there any way for us to enforce the factor that he has yet to get her allergy meds?
Did you bring that up in the motion?
I had forgotten about that.
I can't order it because it's not brought before the court, but I'm going to strongly, if he's watching, I'm going to strongly encourage the defendant to make sure that all medications are provided as prescribed and returned properly when the parenting time is over.
And the beautiful thing is, if he doesn't want to return them, he can pick them up over the counter.
You can do that as well. All right. I wish you the best. We're all set.
Thank you.
Take you off the record. Hopefully you get to work somewhat on time.
At least it's not going to be too late. I appreciate it.
Mr. Cola's request for interim relief. He is present, represented by Attorney Jessica Risky. Ms. Amanda Algola appears in pro se.
Your Honor, as my motion states, Mr. Gola is the sole owner of the home located, he purchased that home 12 years ago, well before the marriage. He has been paying to maintain that property since the parties have separated. The parties married in April 2023. It wasn't until many months later that the defendant actually was staying at that home until like August of 2023. Their relationship ceased in December of 2023. In the meantime, he has been continuing to maintain all of the bills and having to pay electric, water, sewer, trash, and the gas bill. He's also had to pay $150 fee to stay elsewhere. And there is a huge concern that the property is going to be dissipated and frankly, not maintained. It's losing value each and every single day. There's been other issues, other premarital property that was purchased well before the marriage, owned solely by Mr. Gola, such as car keys, keys to safe, garage door openers, things of that nature that the defendant has taken. She's employed time and she can easily find somewhere else. There's no debts or assets that were acquired during this very brief marriage, and there are no minor children, so this should be a quick and easy divorce proceeding that needs to go.
What about
quickly.
the personal protection?
The personal protection order? In regards to what? Yes, there's a personal protection order and he's not allowed to go there.
Right.
When she is present.
This personal protection order this court had entered.
I don't think we have a personal protection. We've never been served with one. I mean, in regards.
You may not have been served yet.
Okay.
May not have been served yet, but
There's already no contact order through another court order, so I'm not sure why we.
because the court, based upon the reading of the petition, deemed that it was appropriate.
Okay.
There is a personal protection order in effect.
And when was that put into effect?
Sometime earlier this week. We're looking it up right
Okay.
now. Tuesday the 23rd. Expires October 23rd.
Can we be provided a copy of that? So then I guess in that sense, what I would do then, I'll file a motion to terminate and then we can hear that on the same day and then rehear this hearing.
Absolutely no problem.
That would work great.
Yeah, no problem.
Okay. Can that just be emailed to me? And then I can consider that service?
Yep, go to the clerk's office, they can pull the file.
Okay. Okay.
They can,
I'm wondering
Get you
if
a
the
copy
sheriff's
right
office
now.
already has it.
I actually have it right here.
You have to serve it?
Yes.
Then you can serve it.
I just picked it up when I got here.
Okay. Do you acknowledge service?
I'll look out with service, yes. I just want a copy of it so then I can.
Do you have a copy of it, Ms. Goldman? Provide. Ms. Risky. And then Ms. Risky, you'll just renotice this matter to cover both at the same time.
This is the order. I need a copy of the petition too. It's the next part.
The clerk's office will want to copy.
Okay. Well, I just want to put it on record. It's for good to serve me with that as well.
Okay.
But I will get a copy from you first.
Very good.
All right, thank you.
Thank you. On the motion regarding custody and other matters, parties are present. Pro se, would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? I do.
Thank you. You may put your hands down. Ms. Schultz, what is the current status of the custody order relative to the parties?
The parties are granted, Ms. Plant is granted sole legal and sole physical custody according to the judgment of the courts that entered on February 17th of 2022. Time pursuant to that same order is granted to Mr. Plant on alternate weekends and holidays pursuant to the 2016 Huron County Friends of the Court parenting time schedule, except that weekends are Friday at 6 until Sunday.
Thank you. Mr. Plantz, why do you believe that custody should be visited here?
Because her boyfriend is very abusive to her, and they're around my kids, and I'm very concerned about my kids.
I did notice in your motion that there was a judgment of sentence attached indicating that on April 4th of this year, a Brandon Keith Cressel, Cressl, pled to second domestic violence second in the district court here in County, and at that time it appears that the defendant in that case was sentenced, amongst other things, to 24 days in jail, 24 days credit. What specific firsthand information do you have regarding this, other than this clearly a conviction, that would indicate that there's issues relative to children, that they may be in harm?
I do have papers from my apartment complex. I do have from the police department, and I do have CPS.
All right, so Child Protective Services, you claim is involved?
Yes.
In what way?
Because of Brandon.
Did Child Protective Services remove, there's just two children?
Yes.
Did Child Protective Services remove the children from mom's care?
No, they did.
Do you have any firsthand knowledge, not what someone may have told you, do you have any firsthand knowledge of children observing this or in earshot of it, anything like that?
Yes, in the papers, I do have for the CPS workers, we're talking to them, and in here they're saying,
Well, that's hearsay, but do you have any firsthand knowledge that you yourself are aware of children being basically exposed to this?
yes, we were talking at one point, me and Ashley, and I was around and everything like that, and I have seen them to fight many times before. And
Describe what you would say in defining fight.
the only time that I saw them is with the events when he went to jail, because I was right next to him. They were in the vehicle, and I saw Brandon just start punching Ashley in the face, and we're the ones that called the police on him.
Oh, so you saw it firsthand, that's
Yes.
what you're alleging.
Yes.
Were the children around it?
No, they wasn't. They were at school.
Thank goodness. And that's the primary concern?
Yes.
Anything else?
Just, the violence going around in the house. And I don't know, because I'm not there, if the kids are safe or not when he's there.
Do you know whether or not this individual is, other than a dating relationship, is there any marriage or anything between Ms. Plants and this individual, or are they just in a dating relationship?
They're dating.
Ms. Plants, do you have a response?
I have loads of response, but I didn't want to take up everybody's time because I was trying to gather up information and full proof evidence that he is not being 100% honest. For one, I had troubles getting a lawyer because nobody is taking child custody cases right now. So that's another issue. Also, if you need any, because of the issues with Justin and Nicole, because I've also had issues with Nicole, his girlfriend.
Okay, this is not your motion.
Right,
It's his motion.
I'm trying to explain what's going on, but I do have, because of him, I have to have surveillance cameras, not only outside my door, but I have to have them inside due to the false calls he's made to the police.
Okay, but you heard what Mr. Plant stated a moment ago regarding, he claims he observed and called police relative to you being assaulted by this individual. Do you acknowledge that or do you not deny that?
I understand what he's saying, but that is.
No, I didn't ask whether you understood, but is that what
It's
happened?
not true, no.
It's not true?
No, and I did tell the cops that day, and what exactly happened, and Justin convinced the cops so much that they don't even believe me.
Okay, but
So,
this individual pled guilty to domestic violence second in the district court.
because the cops told him there were surveillance cameras, so he wasn't sure if he should agree to it or not. So, but no further evidence was even pulled. The cops wouldn't listen to me that day, and they haven't for a couple years now. So, I've never heard from Justin or anybody else about their concerns about the children.
How old are the children?
9 and 7. And there's also some other things going on that has nothing to do with Brandon, which I'm trying to get more paperwork or something. But we are all, because of Justin, we are all having to take counseling now due to all the trauma he's caused me, and I am seeking CPS
There
due
was
to,
no contact order that was issued in that criminal case.
it was lifted, sir.
No, I understand that, but there was a no contact order ordered originally, correct?
For Brandon or?
Yes.
Yes, for
And it was
24
lifted.
days,
It appears it was lifted on April 4th.
yes.
How many days did you say that this no contact order was in effect?
It was for the 24 days, from the time he got arrested, from, I believe it was March 11th. All we did was just pull into the driveway, and then Justin was attacking our door, but he took it back to something totally different.
You have anything else, sir?
But if you need any, like, for example, any counseling paperwork or anything of that sort of nature, I can get it for you. But I've also had problems at work due to Justin. Him and his girlfriend's been calling my works.
Okay, well, again, that's
Causing that issue.
because you didn't file a motion, but this Mr. Kressel individual, the place that you live at, is that in your name or is it in his name?
Well, I'm on the lease.
Okay.
I'm the lease. I don't own the house or,
No.
right,
Sure.
or building. We are fixing to move due to also, Justin and Nicole. That's another reason why we have to move. He's trying to get us evicted and causing
Who's trying to
quite
get
a, huh?
Who's trying to get you evicted?
Justin and Nicole.
I've heard enough on this.
If you need proof, I
Excuse
can.
me, miss. The issue before the court is whether there's proper cause or change in circumstance that would warrant a review of the custody factors in this case. The plaintiff in this case has sole legal and sole physical custody of the minor children. Father has parenting time on alternate weekends and alternate holidays. That's pursuant to the previous judgment back in February of 2022. The allegation here is domestic violence, where the petitioner, in this case, Mr. Plant, says he saw it, called 911, individual was arrested, and the court records indicate he was subsequently convicted of domestic violence. Second, plaintiff's position is that, oh, nothing happened. There was nothing, police played sides, I'm not sure, but that's the gist of it. Fortunately, the children were not present at the time. However, at this point, I don't know how this may or may not affect the children. Do you see anything going on regarding the effects of the children relative to this individual being around?
Yes, I do.
What have you seen personally?
When I get him on the weekends, my son and my daughter are always telling me.
I don't want you to say what may have been said, but do you believe that based upon this alleged behavior that it's affecting the children?
Yes, I do.
In what way, other than what they're telling you? You see things, how they act.
Yes, how they act and everything like that.
Okay, how do they act?
They both don't know how to control their emotions. With their anger, they're doing it violently with their anger. I've seen it multiple times, and I had to calm them down with their anxiety and everything like that.
How long has Mr. Kressel been in the picture?
Almost about a year.
When did the behavior, you believe, change for the children?
A little bit after the half of the year, like going on.
About 6 months?
About 6 months, yes.
Yes, go ahead. Give any other response?
I'm not sure how to address this, Your Honor, without an issue. But that is the kids have been telling me things as well. So that's another reason why it's a good idea to keep them continuing in counseling, because they're going through some stuff, but it has nothing to do with me and Brandon. I don't have the proof of that right now, other than like I said, I've had surveillance cameras here, but I do have a usually weekly, she's booked for this week coming up. But point being, I do have an ongoing worker, and on top of that, I do have a CPS ongoing worker coming in, so she can verify that the kids are in good hands, etc.
Is there a safety plan in place? Did the Department Child Protective Services issue a safety plan?
I'm not sure. I believe so, but they said part of a good thought was to have the surveillance cameras around and keep going to counseling and continue to do what I'm doing. They told me it would take, if I went up to the welfare office to get all the records, because even before Brandon showed up, we've had issues with CPS that had nothing to do with me, but it's been going on off and on throughout the years. But point being, they told me it was going to take up to 30 days just to get all those records. So I've been trying to get out to the welfare office. My worker told me that I can not do it by, like, for example, online. I have to physically be in that building. So trying to level everything out has been extremely stressful on me, Your Honor. I've been trying to gather up all the evidence and proof for you, but I don't have too much other than, like I said, I've had to put surveillance cameras up and then get the kids not only in the school counseling, but outside services. We all go take care of the list to seek counseling. And I think they said it may take a while for psychological review, but my littlest one is doing a type of testing at the school to see if there's any learning issues, etc. So there's a lot of other stuff continuing.
A lot of moving parts as well.
Right. So I'm not sure though.
Well, this is what the court's going to do at this point. I'm having a difficult time, honestly, Ms. Plantz, believing your statement regarding this alleged domestic violence didn't happen, because not only did Mr. Kressel plead guilty to domestic violence second, but he was represented by an attorney. Attorneys have ethical obligations. They can't plead clients guilty to criminal offenses that they didn't do, because you're put under oath and you have to swear to tell the truth. So when a plea is entered, for instance, they place the person under oath and the person states what they did or didn't do. Clearly, Mr. Kressel did that.
We had to take both had to take the plea deal because there was no other options.
Oh, there's a right to a trial. That's the option. But this is what the court is going to do in the interim. The court finds that there's a change in circumstance. One of the factors in the child custody analysis is any alleged domestic violence either occurring between the parties or with the parties involved. Here, the allegation is domestic violence of an individual, of mother in this case. Now, minor children were not present. Fortunately, they were in school. But under the circumstances, that's a concern of the court.
What about?
Court finds a change in circumstance will order the friend of the court to do a friend of the court investigation regarding custody, parenting time, as well as support. In addition, based upon the allegations contained within the petition so far and the subsequent conviction of Mr. Kressel, court is going to order that Mr. Kressel is off limits to the minor children. He is not to be in or around the children in any way, shape, or form while this matter is pending.
Your Honor.
To ensure the safety of the children.
So even the surveillance cameras are not going to help?
I don't have any surveillance cameras to look at right now. There's nothing before the court. I'm looking at the information provided to the court.
What about the time he pushed him?
File a motion.
Okay.
Right to do that.
So how can I go about doing that?
I can't provide you any legal advice, miss, but I would strongly encourage you to either speak with an attorney or their legal aid centers.
So since Brandon lives with me and we have no proof this didn't happen, then what am I to do? Because Justin's been trying to sabotage every single relationship I've had since we separated.
I'm not going to get into that. All I know is what's before the court right now, and that is my order of false marriage. I'm concerned about the children. That's my number one concern. You're both free to go.
So what does that mean? Does that mean I've never had this happen to me before? So
Mr. Kressel is off limits to minor children.
is that all?
Prior orders will remain in effect.
Do I still get to have my children?
The friend of the court office will send a packet that needs to be completed and returned to us. We'll set up interviews and there will be an investigation.
Prior orders remain in effect. We still have custody. Nothing. Thank you. This is Ms. Geyer's motion regarding parenting time, custody, and other matters. She's present. Court calls Brian Chad Pickenet. No response. Matter scheduled for 9 a.m. It is currently 10:05. The court did inquire of Ms. Geiger whether she believed Mr. Pickenet would be appearing. She advised probably not, I believe, her words. She is in the courtroom, though. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? I do.
Thank you. Ms. Schultz, what is the current order regarding minor child and children?
Your Honor, on June 12th of 2023, a stipulated order was entered regarding custody and parenting time. That order granted the parties joint legal and joint physical custody of H with equal custodial time on a week-to-week basis, as well as alternate holidays pursuant to the 2016 parenting time guidelines. There was previously an order for Ms. Geyer to have sole legal custody, but the parties had worked on communication, has thus stipulated to the order in June. My understanding is that there's been a number of occurrences according to Ms. Geyer's motion that the court will need to consider. I just want to note that the friend of the court does still have a valid bench warrant for Mr. Pickens, based on his failure to appear on a sanction.
Thank you. And the court took judicial notice of its own records as well. There may be a bench warrant out of the court as well. Oh, it's out of this court. I'm sorry. I was mistaken. Okay. Ms. Geiger, you are under oath. Why do you believe that we should be revisiting custody parenting time?
First off, he no longer resides in the county. As far as I know, last I knew, he was living in a garage in Bay City. I know he's been flip-flopping between Bay City and Midland. I don't know his current residence fully. I tried talking to his family even. It's just, he doesn't reside in the county.
As long as he's 100 miles away from the domicile of the minor child, he can move. As long as he's within 100 miles as the crow flies. But, okay, well, that's issue one. What are there any other issues regarding?
He was arrested in March with having methamphetamines and an illegal unauthorized weapon in the passenger seat. He has been aggressive again. And with the catching of the methamphetamines, I am under the impression that he's been using again. And I think that that's not safe around our daughter, Paige, at all.
Is he exercising his custodial time?
No.
When's the last time he did?
Easter. And that was because of his mother and I had communication so that she could spend time with them. And he was there, but not like present, according to the minor child.
All right. Mr. Pickett has failed to appear, obviously, and based upon the information provided by Ms. Geyer, the court is going to order at this time on an interim basis that Ms. Geyer have sole legal, sole physical custody of the minor child. Mr. Pickett, if he wishes to address the matter, and file a motion to address that until such time as he files a notice of hearing, and we have a hearing relative to whether we continue this interim order or not. That remains up to him to decide. But I'm on an interim basis granting you sole legal, sole physical. Is there a support issue relative to this as well, Ms. Shore?
Looking at the file for support, Your Honor, are you also suspending custodial time?
Yes.
There is a support order in place. The parties had stipulated to $75 per month. It appears from the testimony that Mr. Pickenu is released from any incarceration. The court can verify that. Because
you know that?
still
Yes, he was issued rehab over the weekend, but he escorted himself out and has been MIA.
Which county?
He was in Boyne. He was charged in Bay County. He was rehabbed in Boyne, Michigan. And then as far as like I said, I'm not sure where he is at this point. Ever since he came out of rehab, I haven't received a call from him since then or any communication, but he does reach out after bedtime hours to the minor child.
Shall we continue support then?
Unless the friend of the court receives information that we need to review support based on investigation, we can either continue the order or we can look at support because there is a change in parenting time that we want to review as well.
You want us to look at the parent or the support issue as well?
No.
Just continue it as previously ordered? Okay. Support will continue as previously ordered. Interim sole legal, sole physical to mother. Any custodial time with father at this time is suspended. You can file a motion to address it down the road. Again, for the safety of the child. That's what the court's most interested in. You're free to go.
Thank you, Your Honor.
Anything else?
I'll just note that Ms. Geyer has filed communication complaints with the friend of the court office. We are reviewing those, but before we can take any action, we have to look at it.
With that app, actually, is there a way I can set a meeting with you on how to properly get that set up? Because I think there's actually an issue with the app itself because it kicked me out of the chat and I can't
use it at all.
I'm gonna defer to Mr. Holdwood because he's our applicant's expert, so we will call after we're done with hearings and set something up.
Thank you so much.
Thank you. Yes, this is Ms. Benjamin's motion regarding custody. There's also an objection to a child support recommendation. The parties are both present. You both please raise your right hand. Thank you. Can I have something from the front of the court regarding current status? Ms. Schultz, thank you.
Your Honor, on February 12th of 2024, the court entered an order regarding custody and parenting time for the 3 minor children, W, B, and M. That order granted the parties joint legal and joint physical custody, and also established an order for equal custodial time on a week-to-week basis. There were provisions included with regard to the exchange location, no contact with a TAD months, use of APCOs and standard. There is a objection to the friend of the court child support recommendation, as well as Ms. Benjamin's motion regarding custody and parenting.
Thank you. Benjamin, your pleadings indicate that on January 27th, there was an agreement to meet where you get items out of a motor vehicle. Child was brought or in company at the time, and we don't want to mention any children's names. You claim that the child was not properly in a car seat. You asked father where the other 2 children were, and what did he tell you regarding where the children were?
He said they were with Tad Monk at his home.
Okay. Now, that was on January 27th.
Yes, that was before. That was before they had no order.
Okay.
But my sister drives that way to and from work, and Evan had them on Wednesday through Thursday and noticed Tad's Monk's vehicle in their driveway when my children were with Evan. Well, supposed to be with Evan.
How old are the children?
1, 2, and 4.
Is your sister here?
No, she wrote a thing into the front of the court and put it on my file.
You also mentioned something about threatening messages.
Yes.
What is that?
I have multiple threatening messages to me and to other people I'm engaged with, like he's threatened to take my kids away, he's threatened to get me put in jail, threatened multiple lives. Just
Remind me again why.
And I also had to call the police department because I can't remember the date, but I found a tracker on my truck, and the day before he was telling.
Tracker? What do you mean a tracker?
Like a tracker, like he can get it to his phone.
Are you talking these little Apple devices or?
No, it was like a black box. I have a picture on my phone. I would have to look into it. I'd have to look for it. But I did call the police. It was in the spare tire of my truck. And a few days before I'd found that tracker, he was saying, "Oh, what are you doing here? What are you doing there? Oh, I just seen your truck go by my house." And that's all reasons to believe like he is still using drugs, like it's just erratic behavior. It goes down to just stalking me.
Right.
Like I don't know if there's another tracker on my truck, like I've looked for other ones, but I'm still scared that he could be tracking me.
Well, how would you even know that Mr. Shempke is the one that allegedly you replaced it?
Why was he, I have messages stating, "Why are you here? What are you doing at the police department?" Because I was trying to file a report. I was going up to the courthouse. How would he know that I was going to Myers? I have I mean, I don't have them printed out, but I do have them on my phone stating, why are you here?
You also placed in your motion regarding pickup and drop off times that they're not consistent.
Oh, no, he's been on time one time. I've waited a half hour. I actually had to end up leaving with my children because he didn't show up for a whole hour.
Can you give the court anything to indicate how this alleged behavior may affect your children?
My children are always asking, is daddy coming? Are we not going to daddy's today? I'm sitting there I'm sitting there trying to take them for walks, like, cause our drop-offs are at the police department in Caseville and here in front of the sheriff's office. I mean, I can't really just leave the premises and like not be there when if he shows up. Cause I have no idea when he's gonna show up. He's always saying he's 5 minutes out and then it's 10 minutes that he's getting there, like.
Anything else?
No, but
Okay.
with the drug use, I think, and.
Well, do you have any firsthand knowledge of that?
I mean, I have a picture submitted to you that I found in his side-by-side of paraphernalia.
Do you have any indication when that picture was taken?
March. I do believe,
March of,
2024. I don't know if I think I might have the timestamp on that picture. I'm not sure.
there are a lot of text messages I can see.
Yeah, it's just, I mean, there's a lot more, but that was just a few, just to show that there is messaging as to why I would like to go through the app.
Did we order that also?
Yes.
Where did this picture come from?
Off my phone, I took it in his side-by-side.
Well, you took this picture.
Yes,
Is this a fair and accurate depiction of what you saw on the date in question?
yes, sir.
And we're talking about this one.
Yes.
Any objection to its submission?
I have no idea what that picture is. Well, I see it, but like, I don't know why it's being classified as mine.
Well,
I found it in his side-by-side.
in March of this year?
Yes.
Absolutely not.
Anything else?
No, I would like mandatory drug testing when he's with my children. As I would like to change custody to, every other weekend for him, from Thursday to Tuesday. And mandatory drug testing, so I know my children are with a safe and reliable parent. It'd be Thursday from if it's okay, Thursday to 4:30, Thursday from 4:30 to Tuesday to 4:30.
Thank you. Check your response off.
It's definitely just a lot of confusing, nonsense. The only thing that's accurate is that I'm late for drops, and I do include. I message her and I let her know that I'm obviously gonna be late. I definitely don't have a set schedule. I don't get to punch a clock and stuff like that. I have stuff pop up all the time. Other than that, all the rest is pretty well nonsense.
To be fair to say, you're denying
Yeah.
you're even involved in anything like this.
Yeah, exactly. Like, I have no drug charges. I've never ever been in possession of drugs. I have nothing on the record, and there's absolutely no reason for anything to be said on drugs. Plus, at our last hearing, where she was gonna take full custody, but then decided that she wanted to do 50-50, and she threw all that stuff out on February. She literally told you that I proved it to her that I was clean, and I shouldn't even have to, but I did. And she literally told you she has no concerns of drugs in my house.
Right, but that would have been back in February, right?
Well, correct.
This is alleged to be in March.
Yeah, do you have
That's
a,
later.
do you have a timestamp? Because in March, we.
No, I'm taking the testimony of the witness who testified that she took this picture herself of your side-by-side in March of 2024. That's all I have. She did also acknowledge that it's a fair and accurate depiction of what she saw on that date.
Okay, well, in March, she was not around me or my side-by-side, so I'm not sure how in March she could take a picture of something on my property if she was never even around me.
How do you respond to that?
We were around each other. I was going over there doing things with the children and him, which I know I shouldn't have been.
Okay.
And also, I do want to add another thing to what I've said. I also would like sole legal because I am trying to, for B, we are having issues with his speech and like, I'm just noticing signs of autism. And I had asked Evan, like, I mean, I actually had told them, because I guess I didn't know that I had to tell him about it, that I was gonna get B tested for autism. And he told me he did not agree with that. But to me, if my son has it, I want to know. I want to get him the help he needs. And if he doesn't, great. And then I also was looking into sniffing because when he was a baby, we had his tongue tie cut. And with my new job, I've been learning more stuff about other things. And I realized that I didn't do exercises with his tongue. So his tongue tie could have grown back, and that could be why his speech is impaired. And I had addressed that to Evan, and then he just kind of changed the subject to something else. So I would like to be able to make decisions on my kids' well-being because I had got them in the counseling.
And you are requesting essentially, though this is physical custody that you're talking about in your motion, but legal custody is relative to this potential medical concern of the child.
Correct. So I just want to be able to make them decisions for them because I feel like that's in their best.
Let me ask Mr. Shepka this. Is there any objection?
Yeah, absolutely. I mean, B does great around me. He talks and he's definitely learned a tremendous amount. He shows no signs of like that he can't do stuff, or it's more so his brother helps and does stuff for him too much. And so B doesn't get a chance to actually express his own feelings and his own emotions and do his own thing because his brother always does it for him. And which I've definitely, made sure to tell W that he needs to let B, talk. He needs to let B do stuff, and he needs to let B be himself. And when I get him back, yeah, it starts all back over again. B doesn't want to talk. B doesn't want to do stuff. W is always doing it for him. W is always running and getting in the way, and just B never gets to be himself. It definitely seems like that's definitely more of a household issue. My dad, which would be the grandparents of the children, they dramatically noticed a huge difference when I had the kids for 3
Well, we can't
years.
talk about what other people see, but you described what you saw. Let me back up to this thing right here. Obviously, you deny this, and I'm assuming you're denying any use of controlled substances, correct?
Right.
Okay. What are the thoughts of, and I do this mutually. I don't do this just for one party. I do it for both. What about the thoughts of, for at least the next 14 days? 14 days, maybe even up to 30 days, random drug screens of both parties.
I give that to myself.
I mean, sure, that's fine, but
It'd be at your own expense.
well, then, I mean, I guess theoretically, like, I don't have any extra money to be throwing and wasting away
Your
for no
Honor, I could
reason.
pay for both of ours.
You'll pay for both?
I can do that.
Okay. The court will take this matter under advisement and will order, actually, we won't go 14, we're going to go to 30 days.
Can I say one thing about it too, though? Like, obviously, if I am clean, which I am, and that's her only fight against me, then if that's the case, if I prove myself right, then, I mean, I should be able to fight for full custody.
Well, I'm not getting into that. Well, that's only one of the issues. The other allegation, is this Mr. Muntz.
And his truck was at my house
Why would his truck be at your house if he's not supposed to be there?
because he borrowed my four-wheeler.
So he would have to have gone to your house.
When the kids were not there on Wednesday morning.
Well, we're going to take that under advisement as well. So it's not just the allegations of controlled substances, it's regarding Mr. Muntz.
And Mr. Muntz has a history of drug problems also.
I'm going to order 30 days of random drug screens of both parties. The plaintiff in this case has agreed to pay for it. How do we set that up?
I would ask that the parties report the chance to change today and we will schedule ranks from there.
Where is that?
Right across. Oh, it's right, yeah, right down here.
Okay.
About a block or so.
Yes, it's in the same plaza as the China King at the end closest to the.
Okay.
So you have one in the back door off the parking lot.
The back door, you said?
So I'll order both parties to meet with them today to get this started. Friend of the court will coordinate that as well. Prior orders remain in effect. And at the next hearing that we schedule after the 30-day time period, will include if there's any allegations of, and this is your motion, so if there are any witnesses that need to be here for either party, you need to have them here.
Okay.
So we can't, for instance, just have a document from an individual saying, well, so-and-so was here. No, we need to be able to cross-examine them.
Okay, so I could still put that into a motion after today about him being around and if my sister.
You can file any motion you wish.
Okay.
You can file any motion you wish, and so is Mr. Shevka entitled to do that.
Okay.
I don't have any problem with that, but we're going to hold this matter under advisement until we reconvene after 30 days.
Okay.
Just a second.
The court is also ordering both parties to sign a release to have those test results.
I was just going to get to that.
Thank
You
you.
need to sign releases to have the front of the court be able to receive this material.
Okay.
Go ahead, sir.
Am I able to address any concerns then right now either? Or,
Well, you didn't file a motion.
right, so I can't. So all I can do is just,
File a motion.
I got you.
Yep, file a motion. And we can probably hear it down, maybe that 30-day time period.
Well, what about if the children have been affected dramatically by violence, directly in the living
File a
quarters?
motion. If it's that important, it should have been filed already. Get it filed. If you have a motion, please file. Ms. Schultz, again.
I'm sorry, Your Honor. Two matters. One is the court directing the parties to begin using AppClose as previously ordered.
Just getting to that as well, too.
And is the court intending to address child support today, or do you want to preserve that issue until we come back?
We're going to preserve child support until we come back. Regarding AppClose in this case, reviewing the text messages, the only way to communicate between the two parties, I'm not sure why we didn't order this originally. I'm not sure. But regardless, I'm ordering AppClose for both.
The court did order.
Oh, I did order it.
In the last one, yes, sir.
Oh,
Okay, so I was unsure. I did not know of that. So I would have used that right away. I would have known.
So we'll direct both parties to follow through with the order. Prior orders remain in effect. So you have to meet with Chance for Change or Chance to Change today. As soon as you leave the courtroom, right down the street, set that up.
We have well, she has a no contact order, because of a domestic violence. And
Well, you don't have to go at the same time. You need to
that's
see
okay.
the
I was just
records today.
saying that. Okay, yeah.
By the close of business today, that needs to be set up.
Okay.
Okay.
And Your Honor, you are ordering Ms. Benjamin to be responsible for the cost.
She offered it.
Yes.
She's
So
willing to.
I just bring that up because I
Could be
assume a
cost.
chance to change will need some form of prepayment for Mr. Shumka's testing because we have to pay everything. So
Okay. I can go in right after and then set it up.
That's how we'll do it. Can we have a question, please?
May 31st.
May 31st, we'll come back,
Okay.
9 a.m.
Okay.
Okay.
Did you have anything else?
I guess, no, I'll have a motion for.
So is everything staying the same then with our?
Prior orders will remain in effect. However, again, it's only alleged, sir. I have made no finding of whether or not this individual was at your residence or not. But he's not to be at your residence in any way, shape, or form.
Even when the
Not
kids
around
aren't there?
Pardon me?
Even when the kids aren't present?
At this point in time, what is it, week to week?
Correct.
With one day in between overnight.
If the children are there, he's not to be there,
Right.
his vehicle's not to be there. Prior orders remain in effect.
Okay.
That's all we need. Thank you. Both free to go.
Thank you.
Is time and date set for continued motion regarding custody, objections, and a show cause regarding contempt. Parties are present. Would you both please raise your right hand?
Your Honor, on February 12th of 2024, a stipulated order entered granting the parties joint legal and joint physical custody of the 3 minor children with custodial time on a week-to-week basis with an alternate midweek overnight. On April 26th, the issue of custody and custodial time as well as child support was taken under advisement. The parties were required to do random drug testing with a chance to change, including a test immediately after the hearing on April 26th. A referral was made by the Friends of the Court Office to a chance to change. And Ms. Benjamin tested on April 26th with negative results. She tested on May 6th with negative results. That was a makeup test from May 4th. She had called the hotline but failed to report for testing. She tested on May 13th with negative results, May 18th with negative results, as well as May 28th with negative results. Mr. Shumka tested on April 26th, negative for substances. It did come back positive for alcohol. However, there is no alcohol provision in the order. On May 4th, he failed to report for testing, but it was indicated that he did call the hotline at 2:43 that afternoon. On May 6th, there was a negative test submission. On May 8th, Mr. Shumka failed to report for testing after calling the hotline at 8:39 a.m. On May 17th, Mr. Shumka called the hotline but failed to report for testing. On May 20th, he was given a makeup test. However, at that time, the collector found him with a device and they had asked him, I'm not sure. The email that I received from Shannon McPherson said the above client came in at 5:32 p.m. to test. When the mail collector was observing the client providing a sample, he noticed the client had a device on him. Mail collector asked him to give it up and the client refused. And when asked the client to provide a sample without a device, he refused, stating he didn't have to pee. The client stated that it was his pee from the morning to test that. He was advised that was not a chance to change policy. The mail collector needs to see it come from the back. They asked him to fill out an admit to use form, which was refused to be signed because he stated he provided a sample. He was again told that is not a chance to change policy. The collector needs to see it come from your back. On May 22nd, Mr. Shumka failed to report for testing and failed to call the hotline. On May 28th, Mr. Shumka failed to report for testing and failed to call the hotline. That was a rescheduled test due to the
All right, Mr. Shumka, what's going on here?
Well, I don't know what the device was because there was no device, but you have the results from that test? I know I provided a sample.
Failed to report. It's not their policy.
Wait, what?
Your Honor, I actually.
No, I'm speaking of this job. Sorry. Failed to report. Why haven't you been tested otherwise?
Well, I have a full-time job and I definitely have a lot more to do and not always in the area. I have a traveling job. I definitely go, out of town. I not always just basically up. I'm not just sitting around here doing nothing. I made multiple tests and that's more than enough.
Okay. All right. That's what the court's going to do. Based upon the motion for custody in this case, the court finds there's a change in circumstance. Specifically, the issues relative to substance use, the court had requested or ordered the parties to attend testing. Both parties somewhat did. Plaintiff did, negative results. Mr. Shemka, negative, May 4th. I did call but did not test. May 6th was negative. May 8th failed to report. May 17th failed to report. May 20th, makeup test. Device was found, denied by the defendant. May 22nd, failed to report or call. May 28th, failed to report or call.
I do have.
Excuse me, sir.
I do have.
You're finished. This is a change in circumstance. Court finds that by a preponderance of the evidence. Based upon that, the court is going to order a friend of the court's investigation, relative to custody, parenting, not time and support. In the interim, at this point in time, the court is going to order that mother have sole fiscal custody of the minor child. However, that does not create an established custodial environment. The child is not to be removed from the state of Michigan, nor more than 100 miles from the child's current location. And father is allowed supervised parenting time. We need to know who the supervisor may be, and it can be on day visits.
How does that work? Do you expect me to not have a job? Like, I have work orders and I have been out of state. I can't just test. How come when she went out of state, or when she had to go on a work event, how come she didn't have to test them days?
Your Honor, I can answer that.
Please.
Ms. Benjamin contacted the friend of the court office and we relayed that information to her chance to change, but she was out of the area and she had a test immediately before and immediately after.
And I work 7 days a week, and I mean, I still took tests, so.
The allegation of substance use and failed to
What
report.
substance use?
Excuse me. Failed to report, failing to test indicates to the court, frankly, I treat them as positives. That's how we proceed.
Because I have a job, you treat me as positive? When I have no,
Sir, if you were court ordered to do something, I'm not going to argue.
I
with
did
you.
do it.
No, you didn't.
Okay.
I find you didn't. Clearly, you didn't do it.
Okay, but the abuse at the house with our kids getting like choked and abused and stuff, that doesn't matter,
If you want
nothing?
to file a motion on that, you certainly can. We can address that at the custodial hearing.
Okay, but I
On an
have,
interim basis, I made my finding. This proceeding is closed.
because I have a job, you didn't take my kids,
Your Honor.
who, and they don't even have a stable house to
Sir,
live at.
please, you don't want to bury yourself any further.
I have a question. Who would, like, you said there would be a supervised visits
You
with
need
the
to have a
parties?
supervisor.
Who would be the supervisor?
If parties cannot agree on a supervisor, you can submit a list to the friend of the court, and then the court will make a decision.
Okay, thank you.
You're both free to go.
Your Honor, there was a show cause filed for denied parent time against Mr. Shemka. Is the court wishing to proceed on that, or is the court wishing for that to be addressed with the investigation?
Be addressed. This is the defendant's objection to proposed order and motion regarding parenting time, alternative dispute resolution and communication. Both parties are present. Would you both please raise your right hand from the front?
Your Honor, we actually have an objection from both parties with regard to the proposed order. The parties did have an opportunity to meet in front of the court staff to address the issues of parenting time, communication. They did come back in for a subsequent session after the objections were filed. But my understanding is that the issues of holidays remain a pending issue. In addition, the pickup times is proposed order. So we would just ask the court to address that.
All right, we'll go right from the top. Holidays. Who has the objection regarding holidays?
Well, we had both, when we met with front of the court, we had both agreed on one thing. And we were gonna just stick with our usual schedule. That way we didn't have to go like a whole week without seeing them. Decided that's the way we were gonna go. Next day, he called friend of court. His girlfriend didn't like that arrangement and wanted a change.
Okay, his girlfriend has nothing to do with the case, obviously, but.
Exactly. Exactly.
Okay, but that was an arrangement that was put together through alternative dispute resolution. It wasn't a court order, though.
It was
Just mutual, trying to work things out,
correct.
right? So was this for instance, a midweek visit? Was that the issue?
No, it was just, we were trying to, our schedules are so screwy and crazy all the time. We're trying to get that situated and.
What does it have to do with holidays, though? I'm confused.
It was the winter break, spring break. I initially had agreed to keeping it on our normal weekly schedule. well, first off, we had went to the front of the court for mediation because I had filed a complaint because of denied parenting time over Thanksgiving.
Which was resolved.
That's what that was about. While we were in there, they were describing the schedule, explaining the schedule, I should say. It was just brought up about changing that. At first, I initially thought, yeah, that's fine. After I thought about it, I'm like, well, that means I'll never have more than 2 nights in a row. Not that I have plans to take my daughter somewhere.
Why are you telling your clients that different stories?
Excuse me, miss, I'm speaking to gentlemen.
But if I ever did want the opportunity to take her somewhere more than 2 nights, because that's the most consecutive nights, I guess we went back to the regular schedule, so 3 nights, but just saying, if I wanted to take her somewhere for more than a few days, I would have to get permission from Miss Indy, where if we kept the normal winter break and spring break, that would give me a week where I would have the opportunity every other year to do something like that.
Okay, so to make sure I have this correct, you met in front of the court for alternative dispute resolution and some sort of arrangement was worked out. But if I have it correct, you agreed just to go the week on, week off, even through the holidays, correct?
Well, we're not week on, week off.
What is the current schedule?
So the current schedule now is Fridays from 1 o'clock. I'll have her Friday from 1, Saturday, and I thought we did agree to changing that to instead of 3 on Sunday to 1 on Sunday.
Yes.
Okay, I'm thoroughly confused.
The parties exchange the child approximately every 2 days during the week, and that's based on their work schedules. Ms. Indu tends to work on the weekends, whereas Mr. Shelby works during the week. And so that is the schedule that works best for their family, but there is an exchange approximately every 2 days at varying times depending on the day.
I see. But how does this affect holidays?
They wanted to continue that regular schedule for winter break and spring break with an exchange every 2 days, except for Christmas Eve, Christmas Day. And that was what had agreed, unless there was a mutual agreement to do a different schedule for those periods. And then after we had prepared the ADR report and the proposed order, Mr. Shelby had advised that he didn't want to do that, so winter break.
What did he wish to have?
Standard alternate years under the 97.
And how does that differ from our current guidelines?
They're not significantly different for spring break and winter break. The primary difference would be the designation on whose year it is, because 97 is based on plaintiff defendant as opposed to mother. The Christmas exchange is different.
I see.
But the parties had addressed that separately from the spring break and the winter break.
Okay, so we're okay with Christmas.
Yes.
But it's the spring break and winter break otherwise. So I think I've got it then. And that would be, except for Christmas is addressed, but during the winter break and spring break, the original understanding was the every 2 day switch. Is that correct, sir?
Yes.
Okay. And you agreed to that, at least at the time you were discussing this with the friend of the court.
Correct.
And mother. So why do you wish to have to change?
Well, like I said, we went in there talking about denied parenting time. I wasn't even thinking about having a schedule change. So when that was brought up, I didn't have much time to think about it. And I was just like, well, yeah, that's fine. After I had time to think about it, I was like, well, that just took away any chance I had if I ever wanted to take my daughter somewhere more than 2 nights.
Sounds like it affects both of you.
Right. I mean, it's 2 weeks every other year. And this year she had her Christmas break and Easter break.
But I did offer to give her to you any of the days you want it.
And I would-
The holiday.
And I would do the same, except for if at some point, I don't have anything planned right now. But just if at some point I wanted to, I wanted to be able to have that option to do so.
Okay, so what about we keep the current order in place? However, if the parties mutually agree to something else, so long as both parties agree, you could do it.
Well, I thought we had an agreement to where we would keep it like it is. However, if it was going to be what my scheduled week would be, and I did decide to go somewhere, I would have to give the front of the court 2-month notice. And then it would, if her and I didn't mutually agree to it.
Was that part of this?
That was discussed at the subsequent ADR session, because the parties did come back in and meet. And that winter and spring breaks remained a sticking issue for them on how to proceed. And that was what I had proposed, is that we treat those breaks like we treat our extended summer periods, where 2 months in advance, if you wish to take a full break, you provide that notice. Otherwise, we follow your regular schedule. And that way it granted both parties what they were asking.
Flexibility is what it gives as well. What about that?
I'm good with that.
Can you just explain that? So
Well, I'll let Ms. Schultz explain that.
I'm even confused with it all, so.
So, what I had to propose when you met with Ms. Burskell.
I get what you're saying, I just want to make sure.
Yeah, so for winter break and spring break specifically, just those 2 break periods, you will intend to follow your regular schedule unless the party that would have had the break under the guidelines gives that advance notice in writing to the other parent and the friend of the court office that you're going to exercise it pursuant to the holiday schedule and not your regular.
And if there's no vacations or trips or anything planned, then it just continues.
If the notice is given that they're going to exercise for the holiday schedule, that's what we're going to enforce. It doesn't matter if you're having a staycation or whether you're going somewhere. If the notice is given timely, we would enforce under the holiday schedule. If the notice is not given, it will be assumed that you're following your regular schedule.
And so, for instance, if father did want to exercise that, mother could exercise it the next year.
Yes.
And alternate it back and forth so that one party doesn't have an advantage over the other. And that's not obviously what the court's looking for. We're looking out for the best interest of the child. So you understand it now, Miss? Now, because I understand it.
Yeah, I understood it, but I just wanted to make sure. Like I said, our schedules are just a little confusing for everybody.
It sounds like a very confusing schedule, but I give you credit for both being able to support the child. Based upon Ms. Schultz's explanation, do you have any problem with that?
With that, no, I do not.
Sir, you don't.
I don't have a problem.
All right, 1 for 1. Very good. Pickup time. What's the issue with pickup time?
What day?
I didn't think there was an issue with the pickup
What
time.
day?
We did change Sunday to, I thought she wanted Sunday at 1 o'clock instead of 3 o'clock, and I'm fine with that.
Ms. Schultz is nodding.
And so, yeah, that was the only, which I was okay with that. Just I figured 1 o'clock, that gives us more time to do stuff rather than 3 o'clock.
So you like 1?
Yes.
You like 1?
I'm real good with 1.
2 for 2. Ms. Schultz, is there anything else we're missing?
I think the only other thing that we want to place on the record that will, I think, address all the remaining issues, and this is based on the second session, that the parties have reached an agreement that any decisions regarding the child would be discussed and decided upon by themselves only. No third-party interference as to the upbringing of the child. In addition, neither party would discuss the minor child or the domestic relations case with third parties.
Seems to be a no-brainer to me. You have any problem with
Nope, no problem.
I was just having a lot of issues with his current girlfriend butting in with stuff, and
According to this, that's not the end all. It's the 2 of you. You're the
Exactly,
parents.
exactly.
That's the bottom line.
That's how it should be.
Okay, so you're in agreement with that as well?
Yes. he's talking with his clients at work, letting them know everything his girlfriend doesn't like, and they're just running back and telling me all this, so.
Well, let's make this a clean slate.
Okay.
You're both agreeing on something, which is wonderful, and it's the best interest of the child that I care about. No disrespect to you or to you, but I want to make this as smooth as possible for the child, and I'm glad to see that you're both able to talk about this and work it out. Also, probably that Paige, she was involved in this as well.
She was, yeah.
Poor girl.
And as long
I'm
as.
sorry?
all-
I just said poor girl.
Poor girl. Well, that's your job, but.
ADR is not an easy process.
No.
It's not, and it never is. On occasion, parties have already had conversations, but we're here to help facilitate it. As long as the parties can confirm for me that all of their provisions in the order met their agreement, we can draft the final order.
Okay, here we go. Everything okay then?
Yes.
Yes.
Thank you.
Yes.
When do these take effect? Is it 21 days from today?
No,
or-
it,
Right now, okay. So the 1 o'clock, drop off.
As soon as I sign the order, yes.
Perfect.
Officially, it's technically when I sign the order, but I'd ask the parties to follow it now.
Okay.
And the order will be with me, or in my hands, knowing Ms. Schultz's office by the end of the day today, if not earlier.
So what happens if this third party keeps continuing to butt in? Do I just file a motion and just bring it in front of you? Because I've got his clients that are willing to come in and make statements and
if
everything.
there's a written complaint filed with the front of the court office because it's adopted as a communication / parenting time type provision, we'll provide enforcement.
Okay, perfect.
Refreshing. Thank you both. You're both free to go.
Thank you.
Lots of motion regarding parenting time. She is present. Mr. Richardson is present as well. Please raise your right hands.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Again, please don't refer to the child's first name, initials, appropriate. Anything in front of the court.
Your Honor, the stipulated order of the court that entered on November 15th of 2010 granted Ms. Blunt physical custody of the minor child. The parties have joint legal custody. And there is a parenting time order that is subject to the 97 guidelines. I just want to verify that that wasn't subsequent.
Sure.
And that schedule has continued through today.
Wow. Okay, thank you. I read the motion and it appears that mother's issues deal with the Wednesday visit as well as extracurriculars. Is that correct, Ms.?
Yes.
You want to explain that to me, please?
So the reason why we haven't been in here in many years, normally we're pretty mutual on agreements. But as our child gets older, he is,
How old is he?
he is 14.
Wow.
Yes.
Okay. They grow fast.
They do. Michael has not utilized the Wednesdays. I have reminded him multiple times. He will for a while, and then they just go away. And Dakota, he has stated to me that.
We can't go to what he may have said.
Okay. Okay.
What about the extracurriculars?
So sometimes they fall on Michael's weekend, and then he misses out on those.
What type of extracurriculars is
He is in archery and baseball.
And I'm assuming there are activities that occur during Father's time as
Yes.
well. And what's going on with those activities?
Normally they are a few hours away or something. So like, especially with archery, those are on Saturdays or Sundays. And I provide transportation there. When it's his weekend, he just doesn't go.
Okay. Ms. Schultz, can you give some information to the parties relative to that issue of extracurricular?
I can, but can I ask for the court to first verify what schedule they're following, because our order doesn't have any Wednesday visitation.
Okay.
So if they've been doing a further agreement, that's totally fine. I just want to have an order that reflects what the schedule actually is.
Like I said, we've been pretty mutual throughout these years and stuff. I'd like to take back a little bit what I stated. This year, he has now taken him to some archery tournaments.
As it relates to extracurriculars, the friend of the court's position is that we fully support any activities that a child is engaged in. However, it is the other parent, whichever parent has that custodial time, is their right to make those decisions on what activities they participate in. I would encourage that if, especially with archery, which I think is a relatively short season, 2 months approximately.
No, it goes from March until May, I believe.
So a little bit longer. Before doing enrollment, there really should be a discussion about how that impacts the schedule, and how you can adjust the schedule to make up for that. So as an example, if you can't go to visits because of a tournament, then maybe we need to add some additional time to summer break or spring break or winter break to offset.
Try to make it flexible. It sounds like you've been both flexible relative to the time otherwise. And by the way, the court adopts that same policy relative to extracurricular activities. However, when the court says that, it looks to the other parent who may not be taking the child to certain events and say, for instance, why would you deny your child an opportunity and be in an activity that your child definitely enjoys? And if a parent is there, and maybe the non-custodial parent in this situation like dad, I mean, that's great bonding time. And it's a shame if a parent doesn't want to follow that. Now, there may be reasons why the parent can't follow it. They work or they have some other things going on, but the court follows the friend of the court policy, but strongly encourages the other parent, dad, for instance, in this situation, if it's true, that even though you're not mandatorily required to take the child, you're really foolish in not doing it. Because again, if that child loves that activity and the non-custodial parent has time to share that with that child, that creates a better bond with the other parent as well. So, Mr. Richardson, what is your response to all this, sir?
Well, sometimes I do say I don't think he should go to these activities because he has F's on his grades. Back in our day, we used to have C's to play school sports.
I couldn't imagine though, is this a public school that the child attends? We don't even know which school, but it's a public school?
Yes.
Okay. My understanding, and both parties can tell me if I'm wrong, but if the academics are not there, the child would be precluded from playing until the grades are picked up. Is that your understanding, Miss?
There's something I'd like to state.
Well, no, I'm asking you a question.
Yes.
Okay, and sir, is that your understanding as well?
Yeah.
Okay. Mom, is he getting these very low grades as alleged by dad?
He does at times. He gets extra help during school. He does have dyslexia, and he gets help, like he has special ed and classes and stuff that teachers help him throughout the school.
Okay.
And I've never been notified that he can't participate in a sport because of the grades.
All right. It doesn't sound like father has the Wednesday midweek visit, so that point the court finds moot. But relative to this extracurricular, I guess I'm kind of curious. Do they make special accommodations based upon the child to allow the child to be in an activity?
They may, yes.
I'd like to know that if that's the case, though. That would be important because I understand Dad's position as well, but.
Could I add also?
Go ahead, sir.
I have not denied take him. I said I don't think he should go, but I do take him. I'm trying to help him learn stuff at my house That's cooking, mechanic, work, building. He's real good, smart at that stuff. He does tell me he don't want to do archery.
Okay, I can't go to what the
So,
child may have said.
Yep.
I can't go to what the child may have said, but he's in archery right now, though, correct?
Not currently, no, because he's done with it because of him going on a school trip. So there won't be him going to nationals.
What grade is he in?
Eighth.
Eighth grade. What about baseball? Is he baseball at all?
Not currently. I don't have a schedule yet. He is signed up.
All right, here's the ruling. First, again, as I stated regarding the motion relative to removing the Wednesday midweek visit, it's not in the order, so as I stated, that's a moot point. Regarding the extracurricular activity, again, the court's policy and procedure is simply this: strongly encourage it, but if it's on the other parent's time, that other parent has the final say. However, again, Mr. Richardson, I strongly encourage you to think about that, because if the child is interested in the particular activity, whether it's baseball, archery, or building, it doesn't matter what it is. I mean, I guess you can put the shoe on the other foot here. If he's interested in building trades and on mom's time, who has primary custody, says, oh no, we're not going to be doing that. I mean, you understand how that could be affects the child. It goes both ways. I strongly encourage you to be involved in the child's extracurricular activities, but I'm not ordering it. I can't order it under my policy and in front of the court policy. But I strongly encourage you both to sit down about this. And if indeed, because you're able to communicate, if your son doesn't want to do archery, that's a family discussion. If it's baseball, that's a family discussion. But I have to deny the motion relative to the extracurriculars based upon the court's policy. But I think I'm speaking to two reasonable people here that can talk with their son and come up with something that's going to work for everyone. Because I'm, again, no disrespect to either of you, I care about your child.